This next section is entitled Ethical and Legal Issues for your Step 2 CK exam. I probably get more calls, more emails, and hear more from students about this section of the material in the Step 2 exam than any other part of the exam. And it seems to be a source of, well, fairly good frustration for most people. That's unfortunate. The problem here in this section is you have to answer the questions with having a clear sense about what makes a right answer the correct answer. That means the gut instincts that you want to have, the intuitions that you want to work with, is really not the way to go here. When myself and other faculty have been answering questions in this area, we've discovered when we answer questions for students, we have in our heads a set of implicit rules. You ask us a question, we think about what the rule is, and then based on the rule, we can go down through and pick the right answer. Well, what we've done in your syllabus, if you've glanced ahead, is basically we've given you the rules. Your job on the exam is twofold. First, to learn the rules, but then secondly, the harder job, to actually use the rules as you're going through the exam. The process, therefore, to repeat myself, is not you read the clinical case and you know the answer. You're going to read the case, you have to stop and think about what the issue is that applies here, and then you have to pick the answer that matches what the rule says. See, the reason why these questions are frustrating is as you read down through the options, all the options look like there's some truth there, and that's true. All the options do have some truth, but your job is to find the option that is simply the best among all the presented options. The rules are your guide as to what's the best option. Reading down through the options without having a clear sense about what the rules are is basically hunting blind. You can't make a decision unless you have a clear sense about what the decision criterion are. The whole point to this presentation is try to make it clear to you what are the decision criterion so you can come up with the right answer on your Step 2 CK exam. Now, I also want to emphasize at the outset that the right answer on the exam may not necessarily be the right answer in the real world. In the real world, we worry an awful lot about protecting yourself legally, and rightly so. In the real world, we worry about making sure our supervisor is happy with us, and again, rightly so, for simple self-preservation. None of those are criterion for making a right answer on your Step 2 CK exam. The Step 2 CK exam is not about protecting yourself, it's about the right ethical and legal conduct in regards to the patient. And so, please don't take anything I'm going to tell you here today as advice on how to practice medicine in the United States. But please hear everything I'm going to tell you as advice about what's the right answer as you go through your Step 2 CK exam. I want to begin our conversation in this area by focusing on a set of important court cases. There's 5 court cases I want to review as they're presented in your syllabus. Now, I'm reviewing these court cases with you not because you're going to be tested on the cases. No one's going to say, for example, the Karen Ann Quinlan case was about A, B, C. That's considered far too simplistic a question to ask you. But experience suggests to me that by reviewing these court cases, which are the source of some of the key rules I want you to remember, I have an easier time getting to remember and then use the rules as you're going through the real exam. And so, let's begin with the first, the most famous of these court cases, the Karen Ann Quinlan case. Karen Ann was a young woman living in the state of New Jersey, in her early 20s, was out driving around celebrating one Saturday evening with several of her friends. They went out to a bar, had something to drink, drove to another bar, took some pills in between, drank a little bit more, took some more pills. Ooh, alcohol consumption, pill popping together, not a real good combination. At the end of the evening, Karen ended up in the emergency department, non-responsive, and was soon diagnosed as being in a persistent vegetative state. Neurological consult said that, well, given her overall youth and good health, we can keep her alive on life support almost indefinitely, but given the damage that has occurred neurologically, she's unlikely to ever regain any consciousness or any communicating capacity. Her father, upon hearing this, said, well, then let's simply terminate life support and let nature take its course. The doctors were not sure, and so this case ended up in the courts as, importantly, it never would today. Today we have the rule, then they didn't have it, and so they went to court to get the rule. The court listened to what the doctors had to say, listened to what the father had to say, and the court made the following ruling. Let's go with what the father said. Life support was in fact terminated, and miraculously, Karen Ann went on to live for about 4 months without being on any life support, and then she subsequently died. Now that's the case What's the important thing to take out of the case? The important thing is not that the father got to decide. The fact the father got to decide is frankly irrelevant. The important issue is why the father got to decide. Well, the court said, we believe if Karen Ann herself were to set up and have a quote-unquote lucid moment, we believe what the father says is what Karen Ann herself would say. What we get from this case is the crucial doctrine of substituted judgment. Substituted judgment says quite simply, if the patient expressed wishes are not known directly, what we can do is turn to someone who knows the patient best, and they can, based on their experience with this person, estimate what this person most likely would want. Substituted judgment. Now, let's hit the key issue head on here. It's not next of kin. It's never next of kin. Next of kin is an irrelevant consideration. If that's the way you're thinking, get rid of it. It's going to lead you to the wrong answer on your Step 2 CK. It's all about substituted judgment. Who, as presented in the question stem, do you believe best knows the patient's wishes? Now, you may be thinking, well, usually that's the family, and I agree. It often is the family, but it's not necessarily so. We can easily think of some scenarios where somebody other than the patient's family is more likely to have substituted judgment. You can easily conceptualize a scenario where a 36-year-old male patient is brought to the emergency department. He's suffering from HIV, AIDS, and soon lapses into HIV-related dementia. He's now non-communicative. You're trying to decide how aggressively to treat this patient. Given his overall deterioration, he is not likely to ever recover from the vegetative state into which he's lapsed. But given his, well, general youth, he can probably be sustained on life support with aggressive intervention over the next 6 to 7 months. Without the kind of aggressive intervention, he's likely to die, frankly, in a matter of days. As you're trying to decide how aggressively to treat this patient, you turn to his partner, a homosexual companion with whom he's been living over the last 4 years. The partner says, gee, Charlie never said we didn't want done in this circumstance, but if I have to guess, I'd say we shouldn't do anything aggressive because he always said, I don't want to drag this process out. As you're having this conversation, into the emergency department bursts your patient's family. Mother, father, sister, brother, and family dog Spot. The entire family, dog concurring, insists that you do, quote, all possible medical procedures in order to keep their loved one alive for as long as possible. Is it clear what you're going to do? Not yet, it's not. It also says, embedded in the question, that this man's family had been, quote, somewhat estranged from him over the last several years. They hadn't seen him very much because perhaps they did not approve of his lifestyle. Now is it clear what the answer is? Absolutely. Family out, partner in. And please be clear about the rule I'm giving you. I'm not telling you that lovers matter more than mothers. That's not the rule here. The rule is simply confronted with those facts, who do you believe has most chance of knowing the patient's current wishes? Faced with that decision, the predominant decision most people make is that we're going to go with what the partner says. Why? It's about substituted judgment. It's not next of kin. It's never next of kin. It's substituted judgment. Now, I don't know about you, but I personally hate the law. You know why? Because just when they find a great rule you can use, substituted judgment is such a great rule, then they find a bunch of cases where you can't use it. Brother Fox is one such case. Without going into all the details, what you have here is essentially someone who was never competent. Never competent. And if you never were competent, well, we can't say, gee, what will we guess your wishes are, because in the eyes of the law, you never had any wishes. Clearly, you can't use substituted judgment in this context because, well, there's a never-ending loop when we're trying to guess what your wishes are when you've never, in fact, had any wishes. In these circumstances, the court gave us a different rule. When we can't use substituted judgment, we follow a rule called the best interest standard. The best interest standard says we should make a decision for the patient by a simple dispassionate calculus. We should stand and weigh the benefits and burdens of each given course of action and do what the, quote, rational person, unquote, would do under those circumstances. The standard is meant to be very clear. As you're considering an option, if the benefits are great and the burdens are few, do it. As you're considering an option, if the benefits are few and the burdens are great, don't do it. This is meant to be a simple, rational calculus. Now, here's the key things to remember about the best interest standard. First, it's the best interest of the patient only you may consider. You may not consider the good of the family, the good of the hospital, or even the good of all mankind. All that's considered absolutely irrelevant. The only thing you may consider is the interest of the patient. Secondly, when using the best interest standard, if you have strong religious, ethical, moral principles that preclude you from making certain choices, you must set those principles aside. This must be a totally unbiased decision. I like to call this the man or woman from Mars standard. You come down without any preconceptions, do the balance, benefits versus burdens, and make the decision. Third, when we're at the level of the best interest standard, who makes the decision is largely irrelevant. Why? Because anybody at this point making a decision must use the best interest standard. And any two people using the same standard, given the same evidence, should come to the same decision. That means the best interest standard is important for you because, doctor, this is the one time you get to make decisions for your patients. In general, you do not. In general, patients make decisions. You simply follow their decisions. But when we're at the level of the best interest standard, you make the call. Now, please note, you don't get to decide whatever you want. You must decide what the best interest standard dictates. Why do you get to make the call at this point? Well, that's obvious, right? You're highly trained, professional, and an ethical person. Yeah, right. None of that's applicable. The reason why you get to make the call at this point, you're just as good as anybody else. You don't make the call because you're better than anybody else. You make the call because you're just as good as anybody else. So there's no reason not to have you make the decision. Again, you don't get to decide whatever you want. You only get to decide what the best interest standard tells you. So if you're ever thinking, well, most people won't agree with me, but this is what I'm going to do, stop immediately. You're wrong. As soon as you think most people won't agree with you, you're obviously not applying the best interest standard appropriately. If you're ever stuck applying the best interest standard, I have a simple mental device you might find useful. Picture a jury of 12 people drawn from the local community in which you're practicing. Lay before that jury of 12 people all the evidence you have about courses of action, benefits versus burdens. What would those 12 people tell you to do? Whatever you think those 12 people tell you to do, that's what you do. Because that is, pun intended, the court of appeal here, is it not? If you do what a jury of your peers would consent as the right course of action, then you're judgment-proof and you're essentially blameless. This is the best interest standard. When no knowledge is known about the patient's specific wishes, what we're going to do is do for this particular patient what most people in general would want. The rational person standard, the best interest standard. Infant doe is the next case. Infant doe is being presented here not really for the rule it gives us, but because of the extraordinary exception to the rule it gives us. As we'll see a little bit later, parents are not allowed to withhold life or limb-saving treatment from their children. That's a clear rule. They can't do it. If life depends on it, if limb depends on it, it doesn't matter why the parents say no, they don't get to say no. That's the rule. And yet, here's a case, infant doe, where that's just what happened. This is a case from the state of Indiana, just south of Chicago where I'm from. Here you had a mother and father who already had two happy, healthy children. Their third child was born, unfortunately, with a whole long catalog of health problems, including, top of the list, 1, gross retardation with Down syndrome, and 2, a tracheoesophageal fistula. Now come on, unless the fistula is operated on, the child will almost certainly die. Well, the surgeon was called in and provided consultation. The surgeon's consult said, well, we could operate on the fistula, we can, but we have to tell you, given the overarching medical complications here, we give a 50-50 chance of success at best. And, we point out, even if we're maximally successful, the child lives out of state in essentially a custodial state, without any what we usually consider humanity or quality of life. Well, said the parents upon hearing this prognosis, then let's not operate, let's just let nature take its course. And the doctors agreed. The local county prosecutor, however, vehemently disagreed. He said, it's my job to defend the helpless, which this child certainly is, and he sued to force treatment, and he lost. He appealed to the Indiana Supreme Court, the highest court in the state, and he lost again. is getting together this appeal to go all the way to the U.S. Supreme Court, the highest court in the United States, at which point the child died, rendering this case moot. There being no child, there's no reason for the court to make a ruling. Nonetheless, this precedent is before us. Are there certain, key word, extraordinary circumstances when we can and do withhold life and limb-saving treatment from a child? Clearly, there must be, because this cases and a few others like it do exist. Now listen, if this case troubles you, you're not alone out there. If this case bothers you or makes you angry, you have a lot of company out there, but take those emotions and set them aside. They're not exam relevant. What is exam relevant? How the parents, the doctors, and the courts made the decision. Each of these made the decision using the standard we've just had, the best interest standard. Stand with me now, dispassionately, putting aside your biases, your internal feelings, and let's look at the data available. Benefits of treating this child? Few. Burdens of treating this child? High. What does the best interest standard tell you to do? And so the parents, the doctors, and the courts decided. Infant dose stands, therefore, as an extraordinary exception to the rule that parents cannot withhold life or limb-saving treatment. What's the one time when we do withhold treatment? When the best interest standard says, in essence, why bother? When the best interest standard says there's no, on the balance, benefit to doing this. Number 4, Roe versus Wade. Roe versus Wade is known to most people in the United States as the so-called abortion legalizing decision. I hate that label on so many bases. Here's just a couple of them. First, abortion was, if you read your history, already legal in some of these 50 United States. It wasn't that there was no abortion anywhere, and one day the Supreme Court woke up and said, hey, you know what would be fun? Let's vote for abortion. And second, put abortion aside. We're not even talking about Roe v. Wade because of abortion. If you think abortion is murder, think abortion is salvation, I don't care, because those issues are not exam relevant. Set them aside. The reason why we're talking about Roe v. Wade is there's implications in here that are far more profound than abortion, however you feel about it. The core issue in Roe v. Wade is not about abortion. It goes to the very heart of a simple issue. Who makes medical decisions in the United States? The Supreme Court said we're called upon to do a very difficult moral calculus. We have to weigh the rights of the mother to control her own body versus the rights of the unborn child. Well, said the Supreme Court, in the first trimester, we'll make the call. Mother wins. Mother gets to decide. In the second 2 trimesters, said the Supreme Court, we have nothing to say, which is why abortion laws differ radically across the United States in the second 2 trimesters, but why there's uniformity within the first trimester. Each of the individual 50 state legislatures can vote whatever they want in the second 2 trimesters, but the first trimester, mother gets to decide. Now again, put abortion aside, that's not really why we're talking about Roe versus Wade. Look at the implications here. Even in the case where we're killing the unborn child, the mother gets to make that call. Then clearly, if there is no unborn child to take into consideration, the mother still gets to decide what happens to her body. And clearly, if the woman gets to decide what happens to her, a man gets to decide what happens to him. The implications of Roe v. Wade are far more profound than mere abortion, however you think about it. They go to the very heart of the key issue, who makes medical decisions in the United States? Who makes medical decisions in the United States? That's easy. Patients do, doctors don't. Doctor, if you really do your job the way you're supposed to do your job, you will never make a single medical decision your entire career. Well, it's just not your job to do so. Your job is, pardon the metaphor, but it's the accurate one, your job is as a waiter or waitress. Your job is to come before the patient and lay out the options. Here we have the treatment options. You might want to consider the triple bypass. That's been very good lately. And then the patient decides. Can you recommend? Did you ever have a waiter who didn't? Not the fish. But if they order the fish, you bring the fish. You lay out the options, they make choices, and your job is to bring about their choice. The patient is the primary decision maker, the physician is not. And this makes the practice of medicine in the United States not unique in the world, but different than certainly in many other places. If I can get you to really grasp this principle and hold on to it, carry it like a banner through the exam, without exaggeration, fully 1/2 of the ethical legal questions are now easy. Patients make medical decisions, physicians don't. If this troubles you, if you think this is bad, if you think, well, I'm better trained and more intelligent than most of my patients, well, you're right. You are better trained and probably more intelligent than most of your patients. But the issue is not who's smarter. The issue is who owns the body. You're thinking about this like being a physician looking down at a patient lying on the gurney. Here's what I want you to do. In your mind's eye, push the patient off the gurney onto the floor. Now you lay down and you're the patient. Now you're the patient. What rule would you like to have? You get to decide or the physician gets to decide? Well, of course. In a country that purports to be a democracy, what other rule could we possibly have? The patient gets to make the decision. Doctors don't, patients do. The key implication out of Roe versus Wade. Which brings us to our fifth and final case, the Tarasoff decision. Tarasoff decision comes to us from out in the state of California. We had a student enrolled at a university who had just broken up with a long-term girlfriend. And because of that was in some distress. And because of that went in to have several counseling sessions at a university counseling center. In the course of these counseling sessions, he talked about his distress, talked about his relationship, but also talked about, in some fairly graphic terms, some horrible things he wanted to do to his ex-girlfriend. Not just he wanted to kill her, he wanted to, slice her guts open, eat her heart. I'm talking about graphic horror movie kind of stuff. Well, after talking that way in one therapy session, he left the therapy session, and the therapist was so concerned about what she just heard that she picked up the telephone and phoned the police. The police tracked the student down around campus and interviewed him. And the student said, "Man, it's therapy. I'm just talking." That's what you do in therapy. You talk things out. And no crime being committed, the police had to let him go. At this point, the ex-girlfriend called the therapist. The ex-girlfriend says, I'm thinking about going over to where I used to live with my boyfriend and picking up some of my personal effects. I left some clothes, some books over there. I'm thinking about going and picking up my personal effects. The therapist said, "Boy, you might want to wait a little bit before you do that." The ex-girlfriend didn't listen. She went over to pick up her stuff, and remember the kind of stuff he said he was going to do to her in the session? Yeah, he did it all. He didn't just kill her. It's the kind of slashing, blood spatter, horror movie kind of crime that gets on all the tabloids. The therapist, the counseling center, the university by extension were found liable for millions and millions of dollars because the therapist did one thing she should do, call the police, did not do the second thing she should do, warn the victim. Let's be clear. If the therapist had said to the ex-girlfriend when she called, "Don't go near him. You're in imminent danger. I believe your life is a great risk. He was just in here talking about killing you. Please do not go near him. You're in danger." And your girlfriend didn't listen and went to see the ex-boyfriend, there's no liability whatsoever for the therapist. The courts simply held that saying, "Gee, maybe you should wait," wasn't sufficient warning. More information was known, more warning should have been given. What we have, therefore, from the Tarasoff decision is you have a duty to warn and a duty to protect. In a larger sense, what we have from the Tarasoff decision is you're obligated as a physician to, listen, make sure harm doesn't happen. Write it down, underline it. We're going to come back to that again and again because we conned you when you took that initial Hippocratic Oath. Hippocratic Oath says first do no harm. That's not really the oath you took. The real oath you took is not only you can't do harm, you have to stop everybody else from doing harm. If somebody was going to be injured, you could have stopped it and you didn't. There's no excuse. Stop harm from happening. With that in mind, let's try a simple case together. A 47-year-old man, your patient for several years, comes in to see you. You've been treating him for essential hypertension. You give him the standard physical examination, finding his blood pressure elevated. You adjust his medication accordingly. You're sitting at your desk completing paperwork while your patient finishes getting dressed. As the patient finishes getting dressed, he rises, walks to the door, stops, and looks back at you and says, "Doctor, I don't know why I'm going to tell you this. I guess I have to tell somebody. When I leave here, I'm going to go home and kill my wife." He then exits the door. The question now stops and says, what action should the physician take next? Well, if you're thinking about calling the wife, thinking about reporting this to police, you just got the question wrong. Yes, we do need to call the wife. Yes, we do need to make sure the police are notified, but that wasn't what you were asked. You were asked, what should we do next? Well, what you should do is, he just walked out the door, you should go after him. If he's there and you're there, you should intervene. Go after him. Oh, by the way, did I mention that this patient is about 250 pounds of stripling muscle? He lifts weights on a regular basis, looks like a football linebacker. And by the way, you couldn't help notice as he was getting clothed, he stuck a .45 caliber revolver in the waistband of his pants. You want to change your answer now? No. I expect you to go after him. And by the way, not just on the exam, in the real world, I expect you to go after him. Now why? Well, let's rewind. Let's understand what's going on here. Why did he tell you he's going to kill his wife? The answer, of course, is he wants you to stop him. And if you make, I'll allege, even a ritualistic effort to intervene, you will be successful. Now, if you have pig visions of, racing out the door, tackling this guy around the legs, and wrestling his gun away, you've been watching way too much late-night television. I don't expect you to use your brute strength. I expect you to use your best assets, namely your brain and your mouth. You open the door and you say, in essence, whoa, Charlie, come on back. We have to talk about what you just said. And almost universally, I can guarantee you will be successful. If the patient's there, you intervene with the patient there. What if you try that, but he gets away? He runs down the stairs, avoids the elevator, and you hear a squeal of tires as his car pulls out of the parking garage, racing home, you believe, to kill his wife. What action should you take next? Well, the next thing you should do is, of course, pick up the telephone and call the police. Call the police first. Why? 911. You know how to call the police, right? You want to call the wife? You have the wife's number? I mean handy? And if you do, sir, we should probably talk about that, don't you think? What you want to do is call the police, because you know how to do that, get on record, and then, are you done? No, of course not. After calling the police, then you have to call the wife. But folks, that's not the exam question anymore. Call the wife. They all think you all know that you're supposed to call the wife. The exam question is, what do you say when you call the wife? Here's 10 quotes. Because what's important is not that you know to call. What's important is that you can execute the call correctly, that you know the right thing to say. Let's understand what's in play here. There's a second case we lovingly refer to as Tarasov 2 that tells us the following. If you tell somebody that your patient, for example, is coming to harm them, and because of that warning, the person does something to defend themselves and hurts your patient, yeah, you're liable for that. If they hurt your patient because of the warning you provide, you are liable for that. So clearly, what you say to the wife when you call is of extreme importance, right? What are you going to say? Stop looking at the options. What you first want to do is decide what you want to accomplish in this scenario. Well, what I want to accomplish is 3 things. At the end of the day, 1, the wife should be safe and unharmed. 2, my patient should be safe and uninjured. And 3, I should know that it's handled. And now, with that in mind, read down through your options. Here's what you're going to see. One of the options will satisfy one of the goals. Another option will satisfy a different goal. Another option will satisfy 2 of the 3. But one and only one option will satisfy 3 of the 3. That's what you pick because it is the best answer. What's a reasonable answer choice? I would call the wife and say, leave home at once. You're in grave danger. Do not wait for your husbands. Come and see me now. You must leave immediately. You're in grave, life-threatening danger. Notice I didn't say your husband's coming home to kill you, because if I did, well, she could quite rationally take measures to defend herself. She could grab the family shotgun, and when he walks in the door, she could blow him away in order to defend herself. And when she does that, you, doctor, are liable for that action she took. What we wanted to do is come and see me. When she comes to see me, I'll lay out all the details. Together, she and I will go to see the police, and this way she's safe, and she can't harm the patient can't harm her. Now, you understand from that template, you have to pick not a reasonable action, but the best possible solution to the presented scenario. You have a duty to warn, a duty to protect, but more than that, what we get from Tarasov is you must stop harm from happening. Those are the 5 court cases. Once again, I do not expect you to be tested where you have to regurgitate information about those court cases. Instead, I review the cases because they're the source of some of the key rules I want you to remember for the exam.